Good afternoon again. This is Dr. Olu Asekun here. Welcome to our podcast today. Today is another beautiful Wednesday. You are welcome. Remember to call your friends, your family members, your colleagues at work to join. Um, this program is every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time, and that is 10 a.m. Pacific Time. That should be, I believe, 7 p.m. Nigerian time right now. So, wherever you may be around the world, you are welcome. Today, we are continuing with our employment-based series. So, today we are treating EB-3. EB-3, Employment-Based Green Card for Skilled Workers. So, as I have indicated previously, there are 5 categories of employment-based way of getting green cards. We have EB-1. We have treated topics on EB-1. We have EB-2, including national interest waiver. We have treated that topic. We have EB-4, that is for religious workers. We have treated that as well. We have EB-5, that is for investors, those who are planning to invest in the United States. We have treated that as well. So today we are treating EB-3, that is skilled workers. Skilled workers. So if you are a skilled worker and you intend to apply for green card in the United States, you can only apply through EB-3. So when we say skilled workers, it does not necessarily mean that you have to have a bachelor's degree. For as long as your occupation is a skilled one, you can always qualify under EB-3. It is the same EB-3 that governs people who are nurses. Remember, to be a nurse, you don't even need a bachelor's degree. You can have a 2-year associate degree in nursing and then take the state exam. Once you have your license, you can apply for green card as a nurse under EB-3. At the same time, if you are a professional, if you have a degree, university degree, you can apply for green card under EB-3. So generally, EB-3 is for skilled workers. So if whatever you do, if you qualify as a skilled worker, you can apply for green card under EB-3. Now, unlike all other employment-based categories, EB-3 is the only employment-based category that is not self-sponsored. You cannot self-apply for green card under EB-3. So it doesn't matter whether you are a nurse, whether you are a professional accountant, maybe you are a doctor, you are an engineer, whatever your profession is. If you are applying as a skilled worker, you cannot apply on your own. It is not a self-petition. There is no provision under EB-3 for self-petitions. So under EB-3, if you are applying for green card, you need a sponsor. You need an employer to sponsor you. So talking about EB-3, we are going to discuss the procedure extensively and, of course, all the questions relating to EB-3. So while I give this preliminary information, if you have questions, as we always do, send in your questions so that we can answer specific questions rather than provide general answers. Yes, I will still provide general answers. I will still provide the general introductory procedure, rules and procedures. But if you have questions, this is the time to start sending in your questions so that by the time I finish the preliminary introduction, then I can start answering your questions. So, EB-3 requires a sponsor. What that means is that because it is employment-based, you need to have an employer. So there has to be a United States-based employer that will be filing EB-3 petition on your behalf if you are planning to apply for green card under EB-3. As I said, EB-3 is the only employment-based category that is not self-sponsored. You cannot do it on your own. You need an employer to petition for you. Now, assuming that, excuse me, assuming that you have an employer, the question is, what do you do next? What is the procedure? As I stated, you cannot apply on your own. So the first thing is to get an employer who will be the sponsor. Now, if you have an employer who is going to be the sponsor, because this is a permanent procedure, is a permanent employment, because if the employment is temporary, you cannot apply for green card. You can only get non-immigrant status. So for you to get green card, it has to be a permanent employment. So if you get an employer who is willing to sponsor you, the first thing that the employer needs to do is to apply for what we call prevailing wage determination. Prevailing wage determination. That is the first step. The employer cannot file any petition. The employer cannot commence the process. The employer cannot do anything. If you find an employer, the first step, if you find an employer who is willing to sponsor you, the first step the employer is going to take is to apply to the Department of Labor for what we call prevailing wage determination. Right now, that process can take several months. So it is always good for the employer to know the procedure so that for EB-3, let me say this. For me, I call EB-3 the bottom of took time consuming. But the first thing, even before the employer places any advertisement or anything, the first thing the employer needs to do is to apply for what we call prevailing wage determination from the Department of Labor. So there is a form for that. So the employer will complete the form and file it with the Department of Labor. Now, like I said, based on experience, that the Department of Labor, they take their time. They may not respond on time. It may take anywhere between 6 weeks and maybe up to 12 weeks. I mean, I think I've seen prevailing wage determination that takes longer than that. But it's always good to start early. Now, what is the purpose of prevailing wage determination? The purpose is for the Department of Labor to determine how much the employer is required to pay for the position. So if the employer started this procedure by advertising the position, the employer may run into trouble in the process. That is why it is important to start with prevailing wage determination, because it is the Department of Labor that will tell the employer how much is the minimum amount. Let me give you an example. Let's say this law office want to hire a lawyer. That will fall under EB-3 category. Like I said, the first thing the office will need to do is to contact the Department of Labor. Okay, we have this position open in Arlington, Texas. How much is a lawyer paid in Arlington? So we submit that application, because if we go ahead and start placing advertisement and start the recruitment process and start applying for the labor certification, at the end of the day, we may run into trouble if the salary that we offered is less than what the Department of Labor consider to be the prevailing wage within that environment, within that area of intended employment. Let's say, using the example that I want to hire a lawyer, let's say I intend to pay that lawyer $100,000, and I started the procedure for labor certification. I placed advertisement and all of that, and then in the middle of the process, I submit application for labor certification. Then the Department of Labor comes back and tells me that, okay, for a lawyer in Arlington, for you to hire a lawyer in Arlington, you have to pay the lawyer $120,000. then there's going to be problem. So it means that all the advertisement that I've done, all the recruitment steps, everything that I've done will come to a waste, because at that moment, it will be clear that the application for labor certification will be denied, because an employer cannot offer anything less than what the Department of Labor prescribed to be the prevailing wage in the area of intended employment. So that is why it is important to commence the process with prevailing wage determination. So, still using the example of a lawyer, the first thing the law office will need to do is to create an account with the Department of Labor. So after creating the account, the employer, that the law office in this case, will now submit application for prevailing wage determination. Okay, the Department of Labor, we have a position of a lawyer that is open. We want to hire somebody. How much are we required to pay the lawyer? This is what the lawyer will be doing. The lawyer will be handling immigration cases. The lawyer will be handling this type of cases and all that. So we state all that in the prevailing wage application and wait for the Department of Labor to come up with a determination. So once they come up with the determination and they give us a figure, now the employer can offer any amount equal to or higher than the prevailing wage amount, but the amount cannot be less. If the amount is $1 short, at the end of the process, the Department of Labor is going to deny it. So the amount that the employer is going to offer cannot be less than the prevailing wage determination. It can be the same and it can be higher. It just cannot be less than the prevailing wage determination amount. So having determined that, the employer will now commence the process of labor certification. I know that there's a podcast where we have dealt with the process of labor certification, but for this purpose of EB-3, I will summarize it. The process of labor certification means that the employer will place advertisement in a major newspaper on two different Sundays, in a major newspaper in the area of intended employment. Since my office is based in Arlington, Texas, so using the example of Dallas, that will be Dallas Morning News. So still using the example of the law office, so if the law office is planning to hire a lawyer, a foreign lawyer, the advertisement will have to be placed in Dallas Morning News. The Department of Labor, the U.S. Department of Labor, for this purpose, they have only recognized Dallas Morning News as a major newspaper in DFW, that is Dallas-Fort Worth Metroplex. So Dallas Morning News is the only newspaper they recognize for that purpose. So the law office will have to place advertisement on two Sundays in Dallas Morning News, using the example of the lawyer. But for other cases, the employer will have to place advertisement in a major newspaper in the area of intended employment. So the employer will have to determine which newspaper is the major one in their state or within their county or their city, and then place advertisement on two Sundays in such a newspaper. In addition to that, the employer will have to place advertisement with the state workforce agency. The state workforce agency, that is where American citizens go to apply for unemployment. Every state in the United States have what is called state workforce agency. In the case of Texas, since I'm using the example of the law office of Olu Asekun, in the case of Texas, that would be Texas Workforce Commission. So Texas Workforce Commission is the state workforce agency in the state of Texas. So the employer will have to place advertisement with the state workforce agency. Like I said, that is where American citizens go to apply for unemployment. So once the advertisement is placed with them, every time an American or a permanent resident apply for unemployment, they will run through their list. If they see any advertisement that is in connection with what the applicant field, let's say a lawyer, for example, decide to apply for unemployment with the state Texas Workforce Agency. Once they see our advertisement, they will direct that lawyer to our office. Oh, you are a lawyer. You said you don't have a job. That's why you are applying for unemployment. You know what? The law office of Olu Asekun has an opening. Go there and apply. So they will direct those American citizens who are applying for unemployment, they will direct them to the employer to apply for the employment. That is why it is mandatory that the employer must place advertisement with the state workforce agency. In addition to that, the employer must place advertisement in the employer's website. If the employer has a website, of course, in this modern age, virtually every employer must have a website. So the employer will be required to place advertisement in the employer's website. Also, the employer is required to place advertisement with at least three online job search websites. That is websites that people go to look for employment. I'm not going to mention websites on this podcast because one, I don't want to give them free advertisement, but I mean, we all know that whenever people are looking for a job, there are several websites where people go to look for unemployment, to look for employment, to go and search for jobs. So at least three of those websites, the employer must place advertisement in those websites. In addition, the employer must place advertisement in the employer's principal place of business. The employer must place advertisement in the employer's principal place of business. Still using the law office of Olu Asekun as an example, our principal place of business will be our reception. Anybody coming into our office, the first port of call is the reception. So they face the receptionist. So using the law office example, we will have to place advertisement at the reception. Job opening, attorney wanted. We will state the condition, offer salary, and all the other requirements. We will place it at the employer's principal place of business. Now, excuse me. Now, in addition to all of that, if after placing all those advertisements, if there are no American citizen who is interested or who is eligible, who is qualified, then the employer will take the next step. And the next step will be to submit an application for labor certification. The employer will have to submit an application for labor certification. Now, before the application for labor certification, the employer has to wait for the advertisement to expire. For example, if the employer placed an advertisement with the state workforce agency, the minimum period for those advertisements is 30 days. So the advertisement must be there for at least 30 days. So an employer cannot place advertisement today and then the following week apply for labor certification. It will be denied because when you place advertisement, you are required to allow people, to allow applicants. You have to give them opportunity to apply for the position. So you can't place advertisement today and by the following week and apply for labor certification telling them you don't have American citizens who are interested. No, it doesn't work that way. So the employer will have to give time. The employer will have to give reasonable time. So even though the advertisement in the major newspaper is only 2 Sundays, which is probably a period of 2 weeks, but you still have, the employer is still required to give a reasonable time after the advertisement to allow people to apply. Of course, the employer can place a deadline. The employer can say, submit your application on or before 15th of March, on or before 30th of March. But there must be a reasonable time between the advertisement and the time given to applicants to apply. Those are some of the things that will show good faith recruitment steps. So, at the expiration of the advertisement period, the employer can now submit an application for labor certification. So that application again will be submitted to the Department of Labor through the account that was initially created when the employer was applying for prevailing wage determination. So this process is called PAM. This process is called PAM. So once the application is submitted, the Department of Labor can do one of three things. The Department of Labor can review the application and summarily approve it. This happens where the Department of Labor has confirmed, or maybe they have a first-hand knowledge that, okay, for this position, there are truly no American citizens who are willing to do this job, who are available to do this job, or who are eligible to do this job. So if they believe it, they can summarily approve the petition, the application. The second thing that the Department of Labor can do is that they can summarily deny it. Now, what will make them summarily deny it is only one thing, and that is if the advertisement violates the law. I've seen so many advertisements that violate the law. I mean, in my podcast where I discussed the labor certification in detail, I remember using an example. Excuse me. I used an example of the law office of Olu Asekun trying to hire an attorney. We practice immigration law. We are in Texas. Texas is a border town to Mexico. Mexico is a country where they speak Spanish. So if we place an advert and the advert says, attorney wanted, competitive salary, send your resume to the law office of Olu Asekun. We provide the address, we provide the email. We state that applicant must have Texas license. Applicant must be able to speak Spanish. Applicant must have at least 1 year experience. We place that kind of advertisement and we intend to process EB-3. I tell you that application for labor certification will be summarily denied. That application will be summarily denied. The Department of Labor will not even need to do anything. Once they see a copy of the advertisement, they will summarily deny it. The simple reason is that that type of advertisement is in violation of law. It is not a requirement for an American citizen to be able to speak Spanish before they can get a job. It doesn't matter whether the job duty requires them to speak Spanish. Yes, if they are able to speak Spanish, it may be an added advantage, but it cannot be a condition for hiring. So it cannot be a condition for placing a job advertisement. So clearly, where an employer indicates that the applicant must be able to speak Spanish, it is clear that such an employer intentionally wanted to exclude American citizens. How many American citizens can speak Spanish? No, it's not required. So if you are able to speak Spanish, yes, it will be an added advantage, but it cannot be a condition for the employment. So such an advertisement will be denied, will be summarily denied. So the third thing that the Department of Labor can do is to audit the employer. The Department of Labor can decide to audit the employer. Before I go further into explaining how audit works, I want to state clearly all this process, everything I've explained so far, we have not even commenced the immigration process. We are still dealing with the Department of Labor. Nothing has been filed. Up to this stage, nothing has been filed with USCIS. We are still dealing with the Department of Labor. So when we are talking about EB-3, EB-3 requires the employer to deal with the Department of Labor first before they can even commence dealing with USCIS. So we are still dealing with the Department of Labor at this stage. So the third thing that the Department of Labor can do is to audit the employer. What does it mean to audit the employer? It simply means that the Department of Labor can send a letter to the employer. Okay, using the law office as an example again. Oh, the law office of Olu Asekun, you told us that to place advertisement in Dallas Morning News. We want to see how many people applied. Can we see copies of their application? Can we see copies of their resume? Why do you believe they are not eligible? Why do you believe that they are not hireable? Oh, you place advertisement with the State Workforce Agency. How many people through that department contacted you? How many applications did you receive? Why do you believe they are not eligible? Did you receive any application through the online platforms? If yes, we want to see copies of the application. Did you even schedule, did you even shortlist any of these applicants? If yes, how did you communicate with them? If you call them over the phone, can we see a copy of your phone record? If you send them an email, can we see a stamped copy of a date stamped copy of your email? If you send them a letter, can we see proof of delivery? So they can decide to audit the employer. Now, if they audit the employer and the outcome of that audit determines that the employer was trying to play smart, that employer can be sanctioned. Remember, part of where the employer is required to place advertisement is the state workforce agency. This is where American citizens go to apply for unemployment. It is possible during the time that the advertisement was placed, it is possible that an American may have applied for unemployment and the Department of Labor may have directed that person to the employer. Oh, you are a lawyer. Law Office of Olu Asekun has an opening. Go there and apply. So if this person came back to the state workforce agency to apply for unemployment 2 months after that, the Department of Labor can ask him, oh, last month or 2 months ago, we told you about the Law Office of Olu Asekun. How come you didn't apply? So that person may have responded by saying that, oh, I sent in my application, but they didn't invite me. Or they invited me for interview. They told me that they will get back to me, and they never did. So the Department of Labor may have been armed with that kind of information, and the employer may not know. So when it comes to auditing, they will start asking all these questions. So at the end of the day, if there is evidence that the employer was actually trying to play smart, if the employer was trying to make sure that the job is reserved for the foreigner, such an employer can be sanctioned. There could be monetary sanctions. There could even be a permanent ban for the employer never to hire a foreigner. So the consequence is really grave, and this is one of the reasons why most companies have indicated they can summarily approve the petition, they can summarily deny the petition, and they can choose to audit the application. So if at the end of the day, if the Department of Labor approve that application, that is the application for labor certification, this is when the employer can now commence the process of filing with immigration, with USCIS. So in this case, the next thing the employer will need to do will be to submit application for immigrant petition for alien worker, Form I-140. At this stage, the employer will need to submit Form I-140, immigrant petition for alien worker. Now, with this petition, the employer will need to attach a copy of the labor certification. The employer will need to attach a copy of the prevailing wage determination. And then the employer will need to attach evidence that the employer can afford the salary they are offering, and of course, evidence that the beneficiary meet all the requirements of the advertisement for the position. So once this application is submitted, that is when that applicant joins the queue. Remember, we are talking about EB-3 here. EB-3 has a limited number of green cards that could be approved annually. The entire employment-based category, that is EB-1, EB-2, EB-3, EB-4, EB-5, all the 5 employment-based categories, immigration can only approve 140,000 green cards annually per year for those 5 categories. EB-1, EB-2, EB-3, EB-4, EB-5. For the entire 5 categories, immigration can only approve 140,000 applications per year. Now, out of that 140,000 applications, Immigration allocated 28.1% of it to EB-1. Another 28.1% was allocated to EB-2. 28.1% was allocated to EB-3. Only 7.1% is allocated to EB-4, and only 7.1% is allocated to EB-5. So I'm not a mathematician, but I know that if you look at 28.1% of 140,000, that will give you about 40,000. I mean, I'm not a mathematician. Maybe you help me with a calculator, but from average, I think it should give you about 40,000. 28.1%. Aha, okay, yeah, I was right. So it will give you about 40,000. So if you know, like I explained before, that EB-3, that is the bottom of the pyramid, in my opinion. It is the bottom of the pyramid. So what that means is that generally, annually, we always have more application in this category, because the requirement is for you just to be a skilled worker. You don't even need to have a bachelor's degree. Just all you need to do is to be a skilled worker. So for that reason, there are more applications in that category. So every year, visa is usually not current for EB-3. So the reason I'm explaining this is that the employer is not going to be able to file application for green card concurrently with the I-140 petition. So if the employer goes through all the steps that I've explained so far, after obtaining the approval of the labor certification, the next thing the employer will do is to submit Form I-140, immigrant petition for alien worker. Again, because visa is not current, the applicant is not able to immediately apply for green card. So, but the date that immigration received that I-140 petition, that date is the date that is called priority date. So now all the applicant will need to do is to continue checking the priority date, to continue checking the visa bulletin. So visa bulletin is released by the Department of Labor at least once every month. So, and they are released ahead of time. For example, they have just released the visa bulletin for March 2024, even though we are still in February. They always release it one month ahead, so that if your visa becomes current, you have a month to prepare to submit your application. So they always release it 1 month ahead. So, but the date that the immigration received the I-140 petition, that date becomes the priority date. Now, in some cases, because we are discussing employment-based now, in some cases, not in all cases, but in some cases, in most of the cases, the date that the employer submit the application for labor certification to the Department of Labor may be the priority date. So it is important to understand all these things. It may look a little technical, but it is very important to understand it. In some cases, the date that the employer submit the application to the Department of Labor, application for labor certification to the Department of Labor, that date may be the priority date. So it is important to understand, but in other cases, it may be the date that the I-140 petition was submitted that will be the priority date. Now, before I continue, I want to state all the process of labor certification that I have explained so far does not apply to nurses. It does not apply to physical therapists. For nurses and physical therapists, they still have to apply for prevailing wage. Every employment-based sponsored category, with the exception of EB-1, EB-2, EB-5. In fact, EB-1, EB-2, EB-4, EB-5, they do not need prevailing wage. But EB-3, all EB-3 requires prevailing wage determination, including nurses, including physical therapists. They all need prevailing wage determination. But nurses are exempt. Nurses and physical therapists, they are exempt from the process of labor certification. Nurses, physical therapists, and pastors and ministers, religious workers, they are exempt from the process of labor certification. So, but for every other category, they have to go through this process called labor certification, and after which they will submit Form I-140, Immigrant Petition for Alien Worker. Again, once the I-140 is submitted, the applicant does not generally have to wait for it to be approved. What the applicant needs to do is to monitor the visa bulletin. As soon as visa is current, even if the petition is still pending, the applicant can submit an application for green card for as soon as the visa becomes current. So once the I-140 is submitted, once the applicant determines his or her priority date, like I said, the priority date in some cases may be the date that the application for labor certification was submitted, and in some cases, it may be the date that the application for immigrant petition was submitted. So the applicant needs to determine his or her own priority date and then use that priority date to monitor visa bulletin. So once visa becomes current, the applicant does not need to wait for the I-140 to be approved. The applicant can go ahead and submit an application for legal permanent resident of the United States. Yeah, I can see that there have been questions. So let me start answering the questions. A lot of questions have come in, but it is important that I explain those basic things. But now let me start answering the questions. The first question: hello, sir. Can you concurrently apply for green card together with the petition? Okay, I think I've already answered that in my explanation. You cannot except visa is current. Visa has to be current, and that is why I took my time to explain all these procedures so that we know when to apply for green card and when to submit only the petition. You can apply concurrently if visa is current, but if visa is not current, you cannot. And like I said, from my experience, I mean, I've been doing this work now for decades. I cannot remember a time when EB-3 was current so as to be able to concurrently file I-140 and I-485. Like I said, it is the bottom of the pyramid. So usually visas are not that current. So, but again, if you are lucky, because there have been situations where I remember it's been a long time now. I think during President George Bush regime, maybe around 2004, 2005, when the process of labor certification used to take years. So in those situations, by the time the labor certification is approved, visa is already current, because this petition, the application for labor certification, may have been pending for 3-4 years. So at that time, yes, by the time the employer want to start applying for I-140, visa may have been current, and in such a situation, the employer may be able to file the I-140 concurrently with the beneficiary's I-485 application. But generally, you cannot file it except visa is current. The next question: if my petition is approved, can my husband and children get green cards too? Oh yes. For every employment-based petition, it covers the entire family. The employer will file the I-140 petition, but the beneficiary is the one that will file the I-485, the application for green card. So if the beneficiary is married, the spouse can be included. If the beneficiary have children, the children can be included for as long as those children are under 21. Because once any of the children is over 21, they are considered to be another family. They are considered to be extended family. They are no longer considered part of the immediate family. But yes, the spouse and the children under 21 can all benefit from the EB-3 application. The next question: what if I have been denied an F1 visa in the past? Will that prevent me from getting an EB-3 green card? Well, it may not. It depends on whether you are maintaining legal status. As I have always said, every employment before does not mean that you are out of status. For as long as you find other ways to maintain legal status, you are still covered. But if after being denied F1, if you have been out of status, especially if you have been out of status for more than 180 days at the time the application for green card is submitted, then it's going to be denied because the grace period is only 180 days. So if you have been out of status for less than 180 days, yes, you can still apply. You will still be within the grace period under AC 21. The next question: what is the I-140 ability to pay employer requirement for the EB green card? I'm not sure this person understands this question. I've already explained all these things. I-140, that is the immigrant petition for alien worker. That can only be filed after the application for permanent labor certification has been approved. That is when the employer have gone through the procedure of placing advertisement, gone through the procedure of recruitment, gone through the procedure of submitting an application for labor certification stating that I've placed all these advertisements, there are no American citizens who are interested or who is eligible or who is qualified. And once the Department of Labor approves that application, it means that the Department of Labor is confirming that truly there are no American citizens who are eligible or who are interested. So it is only after that an I-140 application can be filed. I-140 is immigrant petition for alien worker. So that is what can be filed. Talking about ability to pay, that is dealing with the Department of Labor. That is before you even start the labor certification process. Ability to pay is part of the documentation that the employer will submit along with the I-140 petition. So when an I-140 petition is submitted, the employer is telling USCIS that I want to hire this person. I want to pay this person 100,000. So the employer has to show evidence that, oh, I can afford to pay this person 100,000. Now, talking about ability to pay, under the regulations, where the employer has a minimum of 100 employees or more, then the employer does not need to submit evidence of ability to pay. The employer only needs to write a letter stating that I have under my employment more than 100 employees. So any employer with more than 100 employees do not need to submit any evidence of ability to pay. But if the employer has less than 100 employees, the employer will need to submit evidence that they can actually afford to pay the salary that they are offering. Usually, evidence in this form may be employer's tax return, it may be audited financial statement, it may be bulk money set aside in a bank account, and the employer has numerous ways of showing evidence that they can afford to pay the salary. The next question: can I use premium processing for EB-3? No, sir. Premium processing can only be used for the I-140 petition. But like I said, for EB-3, you have to go through the process of visa bulletin. So if visa is not current, premium processing is useless. So it doesn't. You cannot use premium processing to apply for green card. you can only use premium processing for I-140. So if visa is not current, even if you use premium processing, the I-140 petition is approved, you still have to wait until visa becomes current. If I do premium processing, will I get my green card faster? No, I just answered that. There is no provision for premium processing when we are talking about green card. Green card application does not have provision for premium processing. The next question, if I get my green card through EB-3, will it be a 2 or 10 years? Every employment-based green card, every one of them, with the exception of investors, they all get 10-year green card. It is only investors that get initial 2 years and then get 10 years after. And the reason for that is that when the investor is applying, they are making a lot of promises. I'm going to do this, I'm going to do that. The law requires that each investment must create a minimum of 10 American jobs. So at the time employment based, get 10-year green card. The next question. When I go to renew my green card, do I have to go through the same process and qualify again? Like I said, for EB-3, you don't need to renew your green card because you get 10-year green card. There's no conditional green card. Once you go through all those processes and they approve it, you get your 10 years. Except there is a problem. Usually, after 5 years, you should be able to apply for citizenship. So there may be no need for you to renew your green card. But if you choose not to apply for citizenship, at the end of the 10 years, if you choose to apply to renew your green card, no, you do not go through the process. You just apply normally to renew your green card by filing Form I-90. The next question. I do not have a degree from any college, university. Can I still qualify for EB-3? Oh yes, if you are a skilled worker, it doesn't skilled means that you have a special skill. So it doesn't necessarily require a degree. If whatever you do, if you are skilled in it, of course you need to have some form of certification to confirm that you are. For example, if you go through 2-year college to get an associate degree in nursing, you will still qualify for EB-3. But you still need to show that you have associate degree in nursing. You need to show that you have passed the NCLEX exam and you have the license to practice, because they cannot approve it for you if you are not licensed to practice your profession. The next question. Can my EB-3 petition be converted to EB-1? EB-1 visa is current, but EB-3 is so far away. EB-3 cannot be converted to EB-1, but if you are eligible for EB-1, you can apply separately for EB-1. There is no law that says you cannot file multiple petitions. In fact, there are situations where we file multiple categories for people. As we speak right now, I have a client whose EB-2 petition has been approved already, but visa is not current, so we are not able to apply for green card EB-1 separately, but you cannot convert EB-2 to EB-1. Come to think of it, the requirements are different. EB-3 requires an employer to sponsor. EB-1 does not require an employer to sponsor. It is self-petition, so the requirements are different. So you cannot convert one to the other, but you can file multiple petitions in multiple categories. The next question. Is there an EB-3 adjustment of status interview? Well, it depends. Generally, I will say 90% of EB-3 are approved without interview. 90%. In fact, since I've been practicing, I've only been invited for interview twice on EB-3. Only twice. in decades that I've been doing this job. I've only been invited for interview twice. Usually, things that trigger interview in an employment-based petition, maybe there is need for clarification. Maybe where there are need for clarification, that's when they invite people for interview. Because come to think of it, for most of the employment based, the petition will have been approved. The interview is only based on the green card. And remember, everybody who is applying for green card, they have to show that they are not inadmissible. That means that they do not have any criminal issue that can raise a doubt about their eligibility. That means that their medical is clear. They are not disqualified on the ground on medical ground. That means they are not connected directly or indirectly with terrorism or some other. So they just. The next question: how long do I need to work for the EB-3 related employer? This is a very, very good question. This is a very, very good question because it is going to bring some other things that I may need to explain. Now, the law does not specify a specific period that an applicant must work for an employer. What the law specifies is that the job must be a good faith offer. The offer of employment must be in good faith. So in other words, if the employer decides to go through the labor certification, all this process does not allow the beneficiary to work for the employer. So if the beneficiary has other form of employment authorization that can enable him or her to work for the employer, that is the only time they can work for the employer. Otherwise, this process does not in itself grant a beneficiary the ability to work for the employer until they get to the adjustment of status stage. Now, when they get to the adjustment of status stage, the application usually goes with the application. The adjustment application is usually accompanied by application for employment authorization. So now, if the applicant has been working for the submitted, the applicant after 180 days may be able to change employer without losing the ability to get the green card. The employee may be able to change employer after 180 days without the ability of losing the green card. There's a procedure for that under EB-3. The next question: how long do I need to work? I think I just answered this. Okay, how long does the EB-3 visa last for? EB-3 is a permanent application. It's a green card, so it lasts forever. It doesn't have an expiration. Once the employer goes through this process and the applicant gets green card, you are a permanent resident. So it doesn't have duration. It's not a non-immigrant case. The next question: what evidence must I provide as EB-3 skilled worker? Of course, evidence to show that you are a skilled worker. Whatever skill you have, you show your certification. So if you have an IT, maybe you are is it Microsoft certified? Whatever it is that you have, you have to show your skill. I'm not the one to tell you what skill you have. So if you are claiming to be a skilled worker, what document do you have to show your skill? If you have a degree, you show your certificate. If you have some form of skill training, like they do in the IT world, you show your whatever skill that you have. If you are a nurse, you show your certificate to show that whatever skill that you have to present your certification to show that you have that skill. The next question: how can I appeal a denial of my from I-140 immigrant petition for alien worker petition. You cannot appeal. It is only the employer. Remember, immigrant petition for alien worker is a petition filed by the employer. It is not filed by an applicant. For EB-3 purpose, this is not a self-petition, so you cannot appeal. It is only the employer who can appeal. And of course, the process depends on the ground for appeal. If the ground for appeal is based on the failure to provide some documentation, or maybe inability to provide certain documentation, or if the employer has some documentations that were not provided before, appeal may not be the right step. Motion to reopen may be the right step, because if the employer files an appeal, appellate court will not consider new evidence on appeal. So if there are new evidence you want them to consider, you should not file an appeal. You should file a motion to reopen using Form I-290B. But if you submit new evidence along with your appeal, those new evidence will be discountenanced. So it will not have any effect, and your appeal is likely going to be denied. So if you know that you have new document, something new that the employer didn't submit before, which they want them to consider, it is better to file a motion to reopen. The next question. Can I work while waiting for my EB-3? You have to be able to be in legal status. So if you have other means of working, yes, you can work. But if your adjustment application has not been filed, you cannot work except you have other means. You may have other means of working. For example, if the employer has previously filed H-1B for you, you can continue to be on H-1B. H-1B is usually valid for initial 3 years. It is also renewable for a second 3 years, making a total of 6 years. And in some cases, where your I-140 petition or the application for labor certification has been pending for more than 1 year while you are on H-1B, your H-1B can be renewed, can be extended beyond the 6 years. You can continue to renew it perpetually until visa becomes available. That is, if your application for labor certification or your I-140 application has been pending for at least 1 year before the expiration of your H-1B, you can continue to renew the H-1B until whenever visa becomes available, which means you can continue to work for the employer. The next question. Can an EB-3 green card be revoked? Well, any green card can be revoked if there is a reason for it. This is not peculiar to EB-3. If there is a reason for it, any visa can be revoked. Even citizenship can be revoked if there is a reason for it. And usually, the reason for revocation will always be maybe immigration discovered that the petition contained misrepresentation, or there were inaccuracies. Maybe they found out that the applicant or the beneficiary was not eligible. Maybe the information provided turned out to be false, or maybe the application for green card, in some cases, maybe there are grounds of inadmissibility which were not disclosed, which immigration found out after the fact, be revoked if immigration can prove that that benefit was obtained fraudulently. It seems that's the last question I have. Do you still have questions I'm expecting? Can you please check? Okay, that seems to be the last question for today. And I just look at the time and also realize that our time is up. I believe that you have enjoyed our programs today, and I want to advise you and plead with you to always remember to invite your family, friends, and colleagues so that everybody will benefit from this vital information. The only reason we are doing this is to prevent our people from making avoidable mistakes, avoidable errors. We are not doing it for any form of benefit. The only reason is just to ensure that our people avoid errors. So if you appreciate it, if you appreciate what we are doing, the only way to show appreciation is to also make sure that other people do not make the same error that you are trying to avoid. The only way to show appreciation is to invite people and let this, and let this information go around so that other people too will avoid all these errors. So we hope you join us next week. Remember, every Wednesday at 12 p.m. Central Standard Time, that is 12 p.m. Dallas time, that is 1 p.m. Eastern Time, and that is 10 a.m. Pacific Time, and currently that is 7 p.m. Nigerian Time. God bless you as you join us next week. And remember, follow us on our social media too, on Instagram, on TikTok. We also provide valuable information. God bless you as we see you next week. Here is Dr. Olu Asekun again.